Alhamdulillah wa salatu wa salamu ala Rasulillah. Welcome to the first episode of the Al-Masā'il Podcast. Now, this specific podcast, bi'idhnillahi ta'ala, we're going to be concentrating on issues of fiqh, specifically contemporary issues. The main reason is there are a lot of contemporary issues that many Muslims living in the West have questions about. And bi'idhnillahi ta'ala, we want this to be a resource for those who have certain questions and may not necessarily be able to find the answer to these questions. We hope that we could be able to answer those specific questions bi'idhnillah. Me and my good friend Sheikh Khalid Hassan bi'idhnillah ta'ala will be going through these issues and trying to break them down and discussing them from many different angles. Now, me and Sheikh Khalid have been good friends for a very, very long time. You know, we first met in 2013, right?
Yeah, back in London. Yeah, London, when we were do the ijra'at to go to Qasim.
Yeah, I remember that. It's a long time.
Okay.
Now, one of the first things I want to concentrate on, and I think it would be a good idea, would be the issues related to Islamic finance.
Mm.
The only reason I kind of picked this issue out many of the different things is when you look at the world of Islamic finance, sometimes you find that there are those who appear to be very strict, and then you find that there are those that appear to be very lenient. You know?
Yeah.
So it's like, are those that are being very strict right? And is being very strict always something that points out that you have the correct opinion? Or are those that are being lenient leaning too much on the arguments of al-Ḍarūrah and maslahah and these type of issues that you find within arguments, So I struggle to sometimes find a little bit of a middle ground that allows people to understand the risks that they're taking when they're entering some of these contracts. When it's Islamic mortgages, whether it's what they deem to be a halal car finance, it's investing in stocks and some of these different things. Some of the rulings regarding buying and purchasing gold online, or even investing in gold online. When you look at a lot of the classical opinions that have a direct relationship between the current opinions, there's a direct relationship between the classical and the contemporary opinions on issues. Those that appear to be very traditional in their approach to fiqh sometimes may come up with certain opinions that appear to be strange, go out of their usul and go outside of the qawaid of their specific madhab. Not only that, it kind of goes against the tradition completely sometimes, So it would be interesting and I'd say important to kind of concentrate on some of these points regarding.
Yeah, 100%. I agree. Yep.
One of the first things I want to do and kind of open up is your experience or even experience in general when it comes to this big topic, because a consistent pattern I keep seeing is a verdict is given. You look back at how the person who gave that verdict understood the circumstance or the situation or the contract.
Yep.
You tend to find that sometimes there's something missing that they didn't know about, or something they had misunderstood, or something that was not clear to them and would have a direct impact on the outcome. But generally, when it comes to studying Islamic finance, you always have to start with the traditional method.
100%.
Because these masail, you have to do the takif.
Yes.
Right? You have to kind of break it down and see what foundational issues are within it, are found within the books of fiqh. Now, your experience with studying this specific subject or this topic in general, al-mu'amalat al-maliyah.
Mu'amalat al-maliyah, yeah.
What would you say it was like? How would you describe it, or what were some of the eye-opening things that you didn't before you kind of entered into this world of
Yeah. So, Bismillah ar-Rahman ar-Rahim, alhamdulillahi rabbil alameen, wassalatu wassalamu ala nabiyyina Muhammadin wa ala alihi wa sahbihi ajma'in, amma ba'd. So I think, well, firstly, Jazakumullah khair for this podcast. It's amazing. For those who don't know, mashallah, Sheikh Muhammad, he gave a very humble introduction. So the reason why me and Muhammad are maybe talking about this is because at the moment, and inshallah there's going to be much more, but we both graduated from the College of Sharia and Jamiat al-Qasim in Saudi Arabia, right? And that Jami'ah in particular, it's not a Jami'ah that's aimed at teaching foreign students. It's aimed at teaching Saudi nationals who a lot of the time are going to enter the judiciary. They're going to enter the legal sector. They're going to enter into the courts. So there was a very big emphasis on studying like Islamic contract law, basically. So we studied traditionally with the mashayikh that we studied with and in the Jami'ah, we studied a lot of Hanbali fiqh, and there was a major emphasis on contract law. Fiqh, and the reason why we call it contract law in the very beginning is because the asl, the foundational approach, or the foundational, everything foundational written on Islamic finance has to come from Islamic contract law. Because for aqd, for a contract to actually occur, there needs to be, or for the selling of goods to occur, there needs to be a contract. So what I would say is, one of the things I found was how advanced Islamic contract law was, but also when you're studying it from the viewpoint of the Messenger of Allah sallallahu alaihi wasallam in his time, your tasawwur, the way in which you imagine money, is completely different, and you realize that you are a person finds himself being not a condition of their time, but you are a product of your time. So for example, I remember mashallah, you would understand this, and one thing I'll say is, mashallah, while we were studying in the kulliyah, Sheikh Muhammad, mashallah, was an excellent student, and I'd a lot of the time refer to him. So one of the things that I could not understand in the very beginning was the hadith of Ribā, hadith of, I think it's Ubad ibn Samit. الذهب بالذهب والفضة بالفضة والبر بالبر والشعير بالشعير وكذا يدا بيد. I could not get over how on earth, I know it's a bartering, but why is the issue, for example, in the prohibition of riba based products, أشياء الربوية, or البضاعة الربوية والأشياء التي فيها riba, those things that are intrinsically have riba within them, because riba is not just a contract, or it's not, sorry, Riba is not simply a loan, because that's what we thought many of us think in the very beginning, right? So, Sheikh Muhammad, the thing I was going to say was, one of the things that I found very fascinating was that the Arabs of old would trade, they would barter two of the same things. So one would say, let's say I've got Indian salt and you have Arabian salt, let's trade the different types of salt, for example. Or I have Indian gold, or I don't know, European gold, Roman gold, and you have Arabian gold. We'll trade gold in exchange for gold. So the Prophet ﷺ laid down those foundations of how we have to trade within them, right? So you had that aspect. Now, from the contract perspective, I found it to be amazing, mashallah, and how advanced Islamic contract law is. But then, like what you said, the problems arise with the issues that happen today. And that's because so many Masā'il have occurred since the time of the Prophet ﷺ in terms of the emergence of Western finance, that one could say that, like, how do you actually picture them or grasp them through an Islamic lens when there's no nadhir, there's nothing similar in the Shariah? And I think a very important one is, for example, an LLC, a limited liability company. So you're going to tell me now that in the Shariah, I can sell, for example, computers, and I'm not considered to be the legal owner, or I'm not considered to be the sole owner of the company. I can set up a separate legal entity that has its own kind of laws attached to it. And then from there, if the business goes bust, I'm not liable for the debts of that business. So that's just one thing. How do we deal with that from a Sharia perspective?
Or like when a person claims bankruptcy.
We think that bankruptcy, exactly.
At the LLC or the limited liability company it's a separate. If he and the West treat it as a separate entity to themselves,
Exactly.
Which when you put it from the angle of the Sharia, something like that, you would have to do a lot of digging to try and kind of recognize the issue in terms of like how do we define this? Because you deal with individual.
Exactly. And another thing would be, Sheikh Muhammad, if somebody looks at why the Sharia hasn't allowed that, it's because a person can then do reckless acts and
Yeah.
won't be held responsible. So the Sharia is trying to take away hiyal and cheating. But Sheikh Muhammad, the question I want to pose to you is, what do you find to be some of the biggest problems or biggest questions in the Sharia, or I mean, sorry, in the Saha right now, in the kind of, in the kind of, in the open kind of discussion? What are some of the issues that you're finding to be a major challenge when it comes to Islamic finance?
I would say one of the things is that when you look at some of the Fatāwā regarding certain clauses institutions can place within contracts, when you look at it from the angle of the customer, you feel a level of sympathy for the customer. And if you do that, then you tend to be a bit more strict in telling them to avoid engaging with this financial institution. When you look at it from the angle of the financial institution, then one thing you come to realize is that if they don't have this clause in place, it's highly likely it may end up and may lead to the collapse of the institution itself. So it's like, how do you balance between the masalih that are related to the consumer and the masalih related to the business themselves? Another issue would be like, how much can you stretch the argument of al-maslahah? Of course, the famous principle, of أن الحاجة العامة تنزل منزلة الضرورة. This is قاعدة مستقرة or قاعدة ثابتة. You find it, she mentions it in his كتاب المنثور. You find it, it's mentioned الأشباه والنظائر by السيوطي. The قاعدة that's used, which is when you find that the need, which is lower than the level of a necessity, becomes widespread, then it takes the similar ruling as a necessity. Well, when you find some people are attacking some of the people that give fatwa on these issues, when you're in that position, you come to realize that it's not as easy as you think it is. Like, to come up with a solution that's beneficial to the Muslims, those living in the West who are living in a financial system that's not, sticking to the Sharia. And what do? Another thing, let me give you another example before I'll give it back to you.
No, go ahead.
For example, the issue of stocks.
Yep.
Right. If you work in the private sector, your pension will be invested. It will be invested in a pension fund.
Exactly. Yeah.
It's invested in a pension fund. Then, of course, you have to place it within a pension fund that is Sharia compliant.
Yeah.
But then the argument about Sharia compliancy comes up, which is that the AAOIFI, I think that's how they pronounce it. The AAOIFI standard or Sharia compliancy regarding stocks is something that you would find the people of knowledge discussing on whether it's even a valid standard because of the issue of the debt-based interest, whether or not you're considered to be a sharik in its complete sense, you're a partner in its complete sense, and they're representing you. And when they take out these riba-based loans, then you're considered to be liable for that. Does that actually exist? Is that a valid argument? Because when you purchase a share of a company, you invest in a specific company, you don't necessarily have the rights that the major shareholders have. You're not brought to the boardroom and they're making major decisions.
Exactly.
So it's like, how do you deal with this issue? Because if you completely write off stocks, then the Muslims who live in the West who work in the private sector and are having their money invested in pension, let's say, for example, Sharia compliant according to the AAOIFI standard.
Yeah.
All of their pensions go out the window.
Exactly.
So what do you do? Do you argue from the angle of al-maslahah? Do you try and maybe respond to the argument of those that say where the company that itself, the foundational financial activity of the company is permissible, and they may have certain forms of debt that are interest based, and they may go on to further take out loans that are interest based, as long as it's a specific percentage, less than 30%.
Yeah, or some third or something like this. Yeah,
and the haram income is less than 5%. Then that's a halal stock, and you argue for it from the angle of al-maslahah, and because of the need. So these challenges exist, and it's it's not things that you just, say, yeah, don't worry, it's not a problem.
Mhm.
Put your money somewhere else.
Mhm.
Allah subhanahu wa ta'ala is al-Razzaq. Of course, Allah is al-Razzaq.
Mhm.
But you have to go out and seek your risk.
Well,
Be wise with your wealth and invest
Exactly.
in certain things.
Exactly.
So when you're trying to kind of look at these arguments, you have to look at it from many different angles. Don't be very narrow-minded in the sense of where you're just looking at it from the angle of the person who's engaging in the contract, right? The
Mhm.
customer. Also
Mhm.
look at it from the angle of the company, or the angle of the institution, or the angle of the the wider
Mhm.
ummah, or the wider Muslim population that live in the West, and the possible detrimental effects it can have on them.
100%.
But there's one thing I wanted to ask you,
Okay.
which is, I know you did your master's in law.
Mhm.
So comparing contract law,
Mhm.
of
Mm.
Western contract law,
Mm.
if I can call it that, correct me
Yeah.
from
Yeah. Yeah.
um, comparing that to the Sharia.
Mhm.
What are some of the things you saw, or you kind of found to be interesting, or something?
I found that. So we had to read through contracts, or we had to go through cases, right? And I found that many of the judgments, the old judgments that these judges ruled in, were basically very similar to what the Sharia brought forth, because we're reading very old rulings from the 1800s, which differ to what's going on now. But one of the issues that I would say that I noticed was this issue of legal problems, or mashakil, in fiqh, when it comes to dealing with Islamic contract law and Islamic finance. They're gonna be ever present, and the reason why is because in terms of the West, there is no concept of using money in an appropriate way.
Mm.
And what I mean by that is there's no kind of contract which can be deemed illegal. Now, there are certain things which obviously are criminal, so no one's gonna, criminal behavior is not permissible. But for example, they have this concept of حرية التعاقد, freedom of contract. So me and you can go and start a business, for example, selling alcohol, for example, right? And that'll be freedom of contract. Now, obviously, as you know, Sheikh Muhammad, because you studied Hanbali fiqh as well as Shafi'i fiqh, we know that, for example, with the Hanabila, anything which is haram, okay, it doesn't have a thaman.
So
Because it's not considered to be mal, because it's haram. So khamr will not have a thaman, right? So what ends up happening is, because society progresses, right, new contracts form, and then sometimes there's 3 or 4 parties in the contract. And when you try to even dig into these contracts and try to look at what the company is actually dealing with, you might find that these companies are sub companies of other parent companies who do so many different, kind of other functions, and they're conglomerates that you're dealing with. And they create these kind of contracts that never used to obviously exist in the past, which obviously presents a problem, right? So, for example, insurance. Why did insurance come about? Insurance came about because people who used to obviously use ships, for example, from one place to the other, didn't want to be gharim, didn't want to be the person that's paying for the damage if their ship breaks. Now in the Sharia, we don't have something similar to that. So how do we even answer this question now when the whole world is kind of using that? Some ulama will say no, it's permissible because of the numbers theory and things like this, the theory of large numbers, or whatever it's called, by I think Mustafa Zarqa and other mashayikh on Islamic finance. But the problem,
yeah, go ahead. So to ask you was, I know you mentioned the issue of similarity. You said that that contract law.
Mhm.
In the what type of law were you? What was it? Were you
So we were doing common law. And one of the issues that I found just to be completely similar in the very beginning was the concept of ijab and qabul, offer and acceptance,
Right.
in a bilateral contract.
Yeah.
So in a contract, for example, you can offer somebody to buy something in the very beginning, and if you offer them something, they'll call it an invitation to treat. So come and look at our products. And obviously in the Sharia, before you buy something, you have this issue of, khiyar al-majlis, khiyar al-shart, khiyar al-sifa, okay, khiyar al-ghaban, these kind of options that you have right before you actually buy the thing. And that a lot of these things kind of come about because the Sharia, when you look at Islam and the religion, it did iqrar of many. Allah subhanahu wa ta'ala did iqrar, basically affirmed many things that people were doing that didn't necessarily go against what Allah subhanahu wa ta'ala wanted in his Shariah, but he put boundaries obviously around how we did trade. So we're not allowed to do trade in illegal things, but you can, obviously we can think that the Arabs of old may have looked and maybe have sat in a majlis before they bought things. So then the Prophet,
good example.
exactly, like Salam, من أسلف في شيء فليسلف في كيل معلوم ووزن معلوم إلى أجل معلوم. Or for example, when the Prophet sallallahu alaihi wasallam said al-Bay'ani bil-khiyar ma lam yatafarraqa, that two people purchasing something, they have the option to leave so long as they have the option to leave the contract if we agree on something, so long as they don't leave in the agreement. So we're both just sitting down at the table negotiating. If I now leave and we don't kind of get to a settlement, the contract isn't binding, right? So you have,
I want to interrupt. Did you see that, if did you come across anything in terms of their contract law being influenced by the contract law of the Muslims?
I definitely saw that. And there's a kind of debate, basically. Some kind of professor, one in particular called George Maqdisi, he says that common law, which is judge-made law, so in the Western sense, faqih-made law, but obviously fuqaha in terms of their Western law, British law started from judgments, common law, and you know this as well, Sheikh Muhammad, right? So judgment-made law precedes Parliament kind of made law, in terms of the judges of old would look at previous judgments and then have to do qiyas for present judgments.
Okay.
So I believe, and Allah knows best, that many of the contracts that they were doing come back to Muslim law. And the reason why I say that is because Islam was dominant in the region, so they had to trade with the Muslims.
Yeah.
And George Maqdisi, he has an opinion that this is the case. And just look at waqf. They have something called a trust. They have no kind of they don't know, for example, Western kind of legal theorists and Western legal experts don't know where did the trust come from. But in Islam we have the waqf,
endowment,
and obviously it's very, it's good because it keeps something in perpetuity, basically, to carry on after a person's gone. So a lot of these things did come from Muslims, in my opinion, when you just look at it, because we look at the timing, and when you look at, for example, just the way in which these functions happen. Having said that, a lot of Orientalists and other people, they argue that the Muslims got it from the Romans, which is not true.
Yeah, of course.
And we know the Muslims got it from the Romans because we have the Sunnah of Rasulullah alayhi wasallam where he shows us where the Prophet got it from. But because they reject the Sunnah and Nabawiyyah, they have to say that it came from the Romans, which is obviously not true at all. So you have these issues, Sheikh Muhammad. But yeah, it's very, very insightful. But the question I want to ask you, Sheikh Muhammad, is how do you feel about this occurrence in the West of perhaps experts who talk about Islamic finance without maybe having a Sharia background? Because finances, and what I mean by that is, and I'm not saying it as a kind of dig at anyone, we're not here to do that, but finance is a larger term when you compare it to Islamic legal law or Islamic contract law. Islamic contract law is the asl, and then, like what you said earlier, everything comes out of there. So what do you think about people who, for example, maybe don't have the best expertise in Islamic law or contract law, at least, then maybe going out and speaking about other issues pertaining to modern day finance?
One thing I realized, if you are going to discuss a mas'ala fiqhiyah from al-mu'amalat al-maliyya al-mu'asira, an issue of fiqh from that's related to the contemporary finance issues, right? If you discuss it with someone who has studied a specific madhab, whether it's the Hanbali madhab or the Shafi'i madhab or the Maliki madhab or the Hanafi madhab, you will find that the conversation will flow because of the fact that there are these, it's like as if you're staying within a specific boundary. You're discussing, debating back and forth, but you're within a boundary where there are certain musallamat, things that you can't change. You can't change the reality of, For example, if you look at the different fuqaha, how they defined mal, how they define what mal is. Of course, there's different discussions on what mal is, but you still see it revolves around within a specific circle.
Exactly, like عين مباحة and things
Yeah,
like that.
ayn, or some of them, even within the madhab of the Shafi'iyya, they discuss the issue of can we define al-manfa'a as a form of actual mal, and something up the qawl of al-Shafi'i rahimahullah, and trying to, they try and present it in a different way. Khatib Sharbini al-Mughni al-Muhtaj talks about this issue, right?
MashaAllah.
But in terms of like يعني the thamara, it's not really much of a difference, especially when you're talking about bay', muqabalatu malin bimal.
Nyalin.
Yeah, and that's how it was defined in the beginning of the Mughal al-Muhtaj regarding double bay'. But you'd see they bring up another definition very shortly. Or Khatib Sharbini brings up another definition shortly after that others they have mentioned, which opens a bit more so that both bay'ul manafi' and bay'ul a'yan enter into the definition, right?
Similar to what the Hanabila say as well.
Yeah, exactly. But coming back to this, so just not to sidetrack. When you're discussing a mas'ala, someone who's Hanbali or Shafi'i or Maliki, study these masail, knows the arkan and the shurut and the mawani and the muqtada of the aqd. And what they know the conditions and the pillars and the preventions and what the contract necessitates. How sometimes if you try and bring a specific condition, it might actually completely ruin the contract, prevent it from taking place instead of actually thinking that it takes place, right?
Yes.
Or sometimes you might even try and place a condition clause within the contract, but it doesn't change the essence of the contract.
Exactly.
So for example, exactly. So let me give an example. مسألة القرض, when it comes to the issue of a loan, the loan, if I attach a certain clause to the loan regarding repayments, pay it back in 20 years, pay it back, have a certain amount of money, pay, even if you have a certain amount of money, you don't need to pay it back right now, pay it back when you're hot. These clauses don't change muqtada al-aqd. They don't change the essence of the contract. It's still considered to be a loan. I've given you money and I want you to give that back to me. Now, if this is the core essence of the contract, where you're not giving me the same ayn, you're not giving me the same exact notes I gave you, you're going to give the badal, you're going to give me the replacement. It's considered to be a qard. It's not it's in terms of
Maria.
yeah, it's not something that I'll give them exactly the same thing. You're not lending them the item, you're giving them the money, they're going to give you the money back. This clause that you might add is just to make it easier for the person to pay back.
Exactly.
It doesn't necessarily change the essence of the contract. Now, if you're discussing this with someone who has been through the sullam al-fiqhi, the fiqhi ladder, you would find it, has kind of had experience with this.
Yeah.
He would understand this straight away. He'd understand this concept straight away.
Yeah.
He'd understand the discussion of the fuqaha regarding الشروط العقد والشروط في العقد, conditions of the contract and the conditions that are
within the contract.
Add to it.
Exactly.
And the discussion of does a shart that is not mufsidun lil aqdi but it is fasidun itself even exist?
Exactly.
Does a condition that doesn't invalidate the contract but it's invalid within itself exist? Then the Hanabila do have a specific opinion on this issue. The other fuqaha may not necessarily agree with them, but they know about it. That's why you would find that they do about it, and they might mention certain quyūd and certain restrictions within their speech to kind of notify you of that indirectly, right? So what I found is when you're discussing a mas'ala fiqhiyya regarding an issue of fiqh regarding al-mu'amalat al-maliyya al-mu'asira, current day fiqh systems, it's someone who hasn't taken that traditional approach, but they just studied the new usage of old terms.
Yes.
مرابحة,
مرابحة,
هي بالتمليك, and الشركة المتناقصة, and these terms that are either coupled together or might have necessarily kind of been used in a little bit of a different way to how it was used previously.
100%.
Those who have just studied that, they're locked into just kind of grasping this is what Islamic finance is, and then you would see they would try and come up with solutions. Okay, I don't know how you can come up with a solution if you're unable to look at a mas'ala, look at a current contemporary issue, do the takif al-fiqhi for it. What is it according to what we find in the books of fiqh? Break it down in the sense of where you can take it apart. This is an element of ضرر. This may be a form of riba. This may necessitate a form of ظلم, certain instances, right? This may not make sense because of the fact that muqtada al-aqd is that, or what the contract necessitates when it comes to al-Buyū wa Shirā, buying and selling, is that the purchaser has the complete rights to the entity he has purchased. Can force him, in essence, foundation, to do certain things with the contract if he doesn't necessarily want to do, or with the item if he doesn't necessarily want to do it. That's why you find the discussion of copyrights comes up. Because Islamically, from a foundation angle,
there's no context.
The current day fuqaha discuss the issue of copyrights because of the harm it entails.
Yes.
Well, look, let's say now I have sold something to you. Now that I've sold it to you, you are the banik. You own the item.
I can do with it what I want.
Do what you want. I have no say. It's gone from my ownership to yours. It's transferred. So if that's the case, you can do what you want with it. But what do we do now with digital assets?
Exactly.
Right? Because with digital assets now, you would find that there could be a great level of ضرر, a great level of harm that could be inflicted upon the producer.
Exactly.
So how do we restrict the producer from being harmed? Because one of the foundational principles in the Shariah is what? La ضرر ولا ضرار. The impermissibility of placing harm upon another person, or producing harm, or facilitating harm, or any of these type of things.
That's another thing, Sheikh Muhammad, when we spoke about how the Sharia tries to prevent hiyal, cheating. What do you do now? Even just another mas'ala now is, what would you say, for example, just theoretically speaking, if we're talking about harming a producer, what would you say if the producer is a company and not even a legal entity in the first place? What would even be the outcome on that? In the sense where, can you just see how this is just making things as it goes along?
So you're dealing with the legal entity, not the individual.
Exactly. So it's, but then obviously that goes to intellectual rights and things like that. Exactly. Yeah.
But then one thing you'd have to see is that, well, to be honest, even if it is the legal entity, you'd see that there's a level of ownership between the legal entity and
the owner. Exactly.
So, but I know what you mean. I know what you mean in terms of how they view the legal entity as it being independent of the person. But coming back to this issue, just not
go ahead.
نستطرد for forever. I find that it's easier to discuss these issues with someone who already has a foundation in these issues.
Exactly.
And I find it difficult to understand how someone can be viewed to be an expert on Islamic finance if they're not an expert in fiqh.
Exactly.
It doesn't make sense to me, because Islamic finance is a section of fiqh. You have to have a malakatun fiqhiyah. You have to have the skills of a faqih for you to be able to come up with solutions, because an expert comes up with solutions. An expert can pinpoint out where there are, these hiyal, these impermissible loopholes, and he can come up with a permissible loophole for you.
Exactly. But not only that, it's not just, even when you said they have to have a malaka, a command of fiqh, not just any fiqh, it's a rub'a, it's like a quarter of all of fiqh. It's a huge section. It's not just some little chapter.
Exactly. Yeah, it's very true. So that's what I kind of see at the moment. But coming back to this issue of riba, when you were studying the topic of riba, because I remember you mentioned the hadith of Ubadah ibn Samit radiyallahu anhu, the topic of riba, I found to be difficult initially as well.
Yes.
Let me tell you why.
Go ahead.
When you look at the way the topic of riba is explained, you would find that they would mention, and I'm going to fast track you through it, right?
Yes.
They will give you let's say, for example, you're studying a road,
Ribā,
right? Or you're studying Zad, which is known as Zad al-Mustaqni', just shorten it.
Yeah. من حفظ الزاد حكم البلاد. Never mind.
You would find that they will mention the whole of the Hanabila.
Yes.
Al-Mawzun, wal-Makil, al-Wazn, wal-Kail, which is the illah of al-Riba.
Yes.
The reasoning behind Riba in terms of weight and volume, right? Then you would see that because practically, when you look at money, no one uses the opinion of the Hanabila anyway today.
Exactly.
So a teacher is now forced to tell you the other opinions. So we can tell you why the paper money it has riba within it. The pounds, the fiat currency has riba within it. So what does he do? He tells you the opinion of the Shafi'iyah. He tells you the opinion of the Malikiyah. He tells you the opinion of the Hanafi madhab. So now you're thinking to yourself, okay, the Hanafis and the Malikis and the Shafi'is and the Hanabila, when it comes to gold and silver, they have different opinions. Some are very similar, if not the same in certain aspects. And then you look at the other asnaf, which is al-burr wal-sha'ir wal-tamr wal-milh, the grains and dates and salt, the food. And you find that they also have different views on it. After the teachers mention all of that, it's as if he scraps it and says, what? خلاص العلة في الذهب والفضة الثمنية في الأصناف الأربعة الطعم مع الكيل والطعم مع الوزن. So you're thinking to yourself, okay, but what about what he's just mentioned? What do I do with all of that? Not only that, when you're studying Hanbali madhab, the tafri'at, which is the subsidiary issues, reasoning of the Hanabila, it's not connected to the reasoning that the teacher has mentioned. So you still have to have the reasoning of the Hanabila in mind, or the reasoning of the Shafi'i, even though the reasoning of the Shafi'i tends to be what a lot of current day fuqaha do tarjih of.
Exactly.
So wherever you're studying, you still have to have that in mind when you're trying to understand the subsidiary issues that are being brought up. Okay, who would I say kind of made the mas'ala easy for me? Because you still have Ribā al-Buyū' and Ribā al-Qurūḍ. You have the riba of loans, and then you have the riba of buying and selling. The riba of loans was easy. Everyone understands the riba of loans. I had to get my head around the riba of buying and selling. I couldn't understand. What do you mean? I have dates and I will sell dates for dates. Why am I going to sell dates for dates? If I want dates, I'll pay for it with.
Yeah, exactly.
If I want salt, I'll pay for it with money. If I want rice, I'll pay for it with money. It didn't make sense to me because I've never experienced this before.
Exactly. So now you have to go back in time and look at, okay, how did they used to buy some from the Prophet?
You have to put a lid on it. Stop asking questions. That's how it was.
This is how it was, yeah.
Don't get into don't open up. Don't try and open a door. It's not meant to be open or can't even be open because it's pointless, right? That's how it was. Just leave it like that. Understand it like that. Now we want to understand the subsidiary issues that are connected to this.
Yes.
Right? Now, who would I say kind of simplified it for me? Or Sheikh Khalid. Sheikh Khalid Sheikh. You know how the Sheikh, he split it up into Ribā al-Buyū', Ribā al-Qurūḍ, and Ribā al-Buyū'.
Which I believe he took from the Shafi'iyah because the Hanabila do not do that taqseem. I've not seen the taqseem in the Kutub al-Hanabila.
Yeah.
Say Ribā al-Buyū' or Ribā al-Qurūḍ. Qurūḍ, afwan.
Okay, that is true. I have seen it.
Even though it's implied, it's known. Ribā al-Fadl is invested.
But coming back to the breakdown of the Sheikh, so the Sheikh he would break down the mas'ala. He would break riba down into two. He said Ribā al-Qurūḍ on one side, Ribā al-Buyū' on another side. The riba of loans on one side, the riba of buying and selling on another side. When he talks about the riba of loans, he first introduces you to Ribā al-Fadl and Ribā al-Nasi'ah. Now, Ribā al-Fadl and Ribā al-Nasi'ah,
yes.
The problem I sometimes find is some interpret it in a little bit of a different way to others. They still somewhat intend a similar thing, but there is that element of difference that can cause you to trip up. So what did the Sheikh do? The Sheikh, he specified Riba al-Fadl to a ziyada and Riba al-Nasi'a to delay.
Yes.
He said, understand Riba al-Fadl as an increase.
Delay, yeah.
He said, understand Riba al-Nasi'a as a delay. Right? So he said, so then he would break down, okay, when it comes to Riba al-Qurūḍ, that you would find within it, the Riba of loans, you would find within it that it can possibly be an aspect of Riba al-Fadl. You'd find within it Riba al-Fadl. Why? Because there is more that is going to be given back in comparison to the amount that was given. So £1,500 is going to be given back when the person only lent £1,000. So there's an extra £500. So he said, with Riba al-Qurūḍ, the Riba of loans, just look at Riba al-Fadl. Just look at al-Fadl, Ziyad. Forget about al-Nasi'a, forget about the delay. The delay you will come to when it comes to purchasing, meaning buying and selling. So when we come now to Riba al-Buyū, he broke it down in the sense of where إن اتحدت في علة الربا واتحد أو إن اتحد في علة الربا واتحد في الجنس, right? If you find that it shares the same reasoning for why it is a ribawi item, and you find that it shares the same jins category of what it is, right? He said in this instance, there's a possibility there could be riba al-fadl and there could be riba al-nasi'a. How? Because with riba al-fadl, you would find that there would be an increase. Because it's the same thing, you have to give the same amount. Dates for dates, 1 kilo for 1 kilo, right? So the fadl would come from 1.5 kilo. I give you 1.5, you give me 1 kilo. So there's fadl in this case, there's extra. The nasi'a would come from the angle of where there would be a delay in receiving the rest. For example, a combination of the two, where I have given you 1 kilo of dates, you will give me 1 kilo of dates. That's the initial agreement. I only have 0.5 kilograms at the moment. So I give you 0.5, you give me 1 kg. Okay. I say to you, I'll give you the 0.5 later on. In circumstance, what do we have? According to the Sheikh, the way he explained it was, you have both Riba al-Fadl and Riba al-Nasi'a. What is the Fadl? What's the extra? That there's an extra 0.5 kg. What's the Nasi'a? There's a delay in the actual amount I'm meant to give you, which is the 0.5. So he said in that type of circumstance, you would find the possibility of al-Fadl wa nasi'a. Then he said the circumstance of where you would find only Fadl and only Nasi'a, not Fadl, is where it is similar in terms of the illah of riba, the reasoning of behind what makes it a ribawi item. So dates for rice, both of them, let's say for example, they are both considered to be a ribawi item, and they share the same reasoning behind why they're a ribawi item. He said in this type of circumstance, there's no fadl. Why? فإذا اختلفت هذه الأصناف فبيعوا كيف شئتم. Right? Hadith of Ubadah bin Samit radiallahu anhu. They're different. Then there can be an element of tafadul. There can be an element of where one is more than the other. But he pointed out there's a possibility of a nasi'a. Why? Because it needs to be spot. I give to you, give to me. Then he summarized it by saying, if you find that one of them doesn't share the same reasoning with the other in terms of what makes it a ribawi item, there will never be riba. So gold for dates, there will never be riba. A car for gold, there will never be riba. If you're exchanging, it's exchanging now. You know. So he would repeat that again and again. Remember with Zad, when he was Zad, he brought it up there when he was explaining Qawā'id al-Aqd again in the masjid. He brought it up again. Even al-Qawā'id Fiqhiyah, he brought it up again. Even so it kind of, because the Sheikh repeated it so many times, it's stuck. And from there on, things like became easier, you know. But there are issues. Not only that, when it comes to studying the traditional Islamic finance, books of fiqh, one of the problems I faced as well was they're giving you examples of contracts. Sometimes you're trying to picture what you can't. So you would read the nas, you understand every single word, you understand the sentence. But the question is, what do you mean? Like, what do you intend? I still don't get what you're trying to get at. So one of the books I benefited from was An-Namla's Sharh on Rawd, which a lot of people bring up.
Yeah, 100%.
Especially what the Sheikh he did in that book, he would give an example for every one of those Masail. One of the things I wanted to bring up was when we look at Islamic finance as it is today, and you look at the conventional banking system, the Western banking system, do you feel like an Islamic system can exist that's completely Islamic within a system of what we have today? Or do you feel like there would always have to be some type of compromise?
There's always, in my opinion, to a certain extent, there's always going to have to be some sort of compromise, because if you look at what we call Islamic finance today, it's actually not Islamic finance. If you want to know Islamic finance, you've got the books of fiqh. So you've got Kitabul Ijara, you've got Babul Ijara, you've got al-Hawala, you've got al-Qurūḍ, you've got al-Rahan. Do you understand? You've got all these things, you've got al-Buyū, you've got, as-Salam, all these old contracts, right? From what I can see, my own istiqra of what's going on right now is current day Islamic finance is a response to Western financial new contracts that have come out, and it's our version of trying to kind of manage the fire, because they've become sa'id. They're everywhere. These contracts have become uqūd sa'ida, muntashira. We can't avoid them, so everything we do is like a takyif. It's like we're trying to kind of do qiyas with it and see how can we bring it into our kind of books of law, books of Islamic fiqh. Whereas some of them, for example, just can't be, some of these contracts can't be fully explained in an Islamic paradigm. So for example, banks, like what you said, a financial institution which creates its own money, for example, and can, control or has control in some times, in terms of its kind of, ability to kind of, in fact, let's make it even more simpler. Fractional reserve banking, for example. So you've got a financial entity that doesn't actually keep the money that you put in it. It lends out money to other people, and then after it gives you back basically a different or a section of the profits it's made from other loans, and gives you back the money that you've had, for example, right? We've never seen something like that in what do you call it, in Islamic finance. So then the ulama will say, okay, so what do we call this kind of Islamic or this kind of financial institution? What's the contract that you're having with the bank? And that's what even shook me up. Okay, so you're telling me that when I get paid, I'm not putting money into a bank and just storing it there. I'm actually entering into a contract with a bank. Many people don't know that you're entering into a contract with a bank. And then obviously now what's that contract?
Let's try and simplify own. But so look, now let's say you open up a bank account with NatWest. Yeah. Or what's an famous American bank? Or JP Morgan,
Wells Fargo or Amex.
Let's say you open up a bank account with them,
and Chase Bank,
and you're placing your money in their account. What is the agreement? What is it like? You would find that exactly, because that's what you think. You think you're just storing your money there like a wadi'ah. Now, if you study the rulings of storing your money with someone else in someone else's property or whatever it may be, and you would find that it's very different to how the banks view your money. So you would find a lot of the people of knowledge today, they describe it as it being a qard in terms of. That's why you would find that the discussion of al-qard, or is it permissible to accept gifts from a bank comes up. So there's so many issues that are intertwined. But what do you say that one of the main reasons is because of the fact that the Muslims are below those Muslim view with the system because of how we felt was out of them.
Yeah, but that's basically what it is. The Muslims are basically now weak to the point where we can't kind of create our own monetary policy, and because we can't create our own kind of monetary policy, we've got a system of law which has been, put onto us, and we have no ability to be independent at the moment. And therefore we're trying to plug holes. Whereas if we actually just implemented what was in the books of the fuqaha, we'll find that poverty would be reduced. Because, for example, when you spoke about entering into a contract like a phone contract or something, why is it that when you enter into a phone contract, everyone skips the large contract that you're given, but you're given maybe 20 pages of documentation just to enter into a kind of phone contract, whereas you don't get to put any shurut on the person that you're buying it from, when in reality you could if you wanted to, but you don't. So you find that it's one large entity with all the power giving you this set of shurut, right? And then what happens when what do you call it? What happens when you're unable to pay? You're charged even more. So what happened to the rahmah? What happened to the rahmah when كان ذو عسرة فنظرة إلى ميسرة? No, they charge you even more. So then you find that when you look at the gharad, or when you look at the kind of the aim of Islamic finance is actually to create a fair market. Whereas when you look at the markets of today, it's actually an unfair market where it's always going to be aimed at large financial institutions profiting off of what you have. So yeah, so then in reality, when it comes to adl, trying to perform adl, trying to have justice in something which is, if you like, intrinsically unjust, is always going to be a very impossible task, because how do you do it? Do you kind of understand?
Of course.
But at the same time, we should work within the system that we have. There was a brother that I know who he took all of his money out of his accounts. He put it all, I think, in Bitcoin or something. He said, I'm not using a bank. And it's just like, well, Akhi al-Kareem, the mas'ala of the Ḍarūrah. If you're forced to and you've got no real other option, you can use the bank and just use it in the way which is halal. You don't, Allah subhanahu wa ta'ala does not want you to, for example, remove you from the financial system so you can't use anything. So there's even that, teaching Muslims how do you navigate
without
the haram in these systems.
this, there is something that I want to bring up, which is that when you look at some of these Islamic finance products, a lot of Muslims would look at it and say that the Islamic finance world is really just a replica of the Western financial world, right? It's just that they replaced the word interest with profit. Yeah, like do you feel like when some Muslims say that, they're justified in saying it, or do you feel like that's a little bit of نوع من التعدي? It's a bit of someone transgressing, going over the boundary.
I think in a certain way there is a level of ta'addi, but there's definitely, I would say, I incline towards the first, the form of what you said, the first part, that a lot of the time it's mustalahat put on haram kind of transaction. So for example, the famous or infamous, administrative fee kind of thing. The the rasm idari, whatever it is, when it's just blatant riba, okay? Late payment fee that they're saying is, it's a kind of fee for
you're charged and it's you don't pay on time.
Tasks, right?
So that makes sense.
Exactly.
But the thing is, Khalid, like if we're gonna be a little bit lost, remember I said to you earlier, when you look at it from the angle of the financial institution, some of these people today don't know how to spend their money. They will buy and buy and buy and take out contracts, and they will end up filing bankruptcy, or they will end up in a state where they can't pay it back. So now, if we remove that clause, for example, then it just leaves it wide open for direct harm to come to these institutions. So it's like, how do you balance it when Islamically it's not really that justifiable? Some try to take the approach of with the condition that's donated to charity, but the agreement itself is still not right, where you're forcing a person to pay back more than they owe just because they didn't pay on time. But let me give you something that I came across, which initially sounds strange, and I still feel a little bit uncomfortable about it, right? Have the Rajihi credit card, right? When you hear it's halal credit card, it's like oil and water. It just doesn't. It doesn't halal pork. Like, it doesn't seem right, because the core essence of your credit card is that Yeah, you're given a line of credit if you don't away from when the
Exactly. And even if you don't pay, and even if you do pay on time, you always have to pay interest fee anyway.
well, the
So,
way that, for example, the way that Rajli broke it down is, the issue of a tawarruq. Now, they've avoided al-'ina. Why? This is what they've done. Well, tawarruq is what is was where, for example, I need money. Come to you, and I say I need money.
Yeah.
So, I buy an item from you. Okay, I buy an item from you. Now I'm in debt. Okay, and then there's two options. I could sell the item to someone else, get cash fast like that. I have the, I still need to get the debt. Or, which is obviously an example or a method that the ulama don't allow in many cases, is if I sell it back to you. Well, I bought the item from you, and I've sold it back to you. Now you're giving me money, and now I'm in debt. That it's a strange procedure, right? Very, very, very shady. Now,
Strange procedure.
the way that Rajhi have set it up is, you will purchase something from them, right, for a profit, apparently. But no, you will purchase something from them.
Yeah.
I'm just to give you an example. I might have to go back to the contract to read it properly, but let me kind of give you an example. You purchase something from them,
Go ahead.
then because the qabd can be hukmi, qabd al-hukmi meaning that you take possession of it right away according to the norms of the customs of society, where it doesn't necessarily have to enter into your actual physical hands. It's regarded as being part of your possession.
Regarded as such.
Obviously, it's not gold and silver because we know of the discussion regarding gold and silver. So let's say, for example, they sell you some type of precious metal, platinum or something. Now you're the owner of it. They now act on behalf of you and they sell it to someone else. That sale, you get the money from that. That's the cash. That is now put into the card. Right? Now you're in debt to them because you have to pay back the money that you owe them. But now you have what can be viewed as a line of credit, but essentially it's an amount of cash that has been placed on the card for you to use. Now this, to me, some of the fuqaha rahimahumullah, hafidhahumullah, I think that they view it to be fine. I think Sheikh Sa'd Khatran, I think, is from them, if I'm not mistaken. But I still feel a little bit.
We spoke about that, if you remember. I remember.
Because of the nature of why the person is taking out the card in the first place. They don't want to buy this thing. They don't even want to sell it. They want money. This item is just being used in a manner where money can be given to you and you have to pay back a certain amount, or you have to pay a certain amount of money, right? So this is an example of
any feasible. It has no feasible effort on the contract. It's just mawjood.
So when some people who are learned or haven't studied fiqh are exposed to something like this, and forgive me, I might have left out certain things from the contract, but roughly this is what I remember what the contract was like. Of course, some Muslims are presenting with something like this. They say, "What is this? I might as well just take out the normal credit card." This is it's a shady way of getting money. It's as if you're trying to trick Allah subhanahu wa ta'ala. It doesn't make sense. It seems to be strange or something. The fitrah finds it difficult to accept. Another thing is that you find that yearly fees that you pay. So they say that those yearly fees are or the admin, or maybe or the use of the card. So, that's some current reform have described it as being impermissible because of this similarity between it and riba. Because now you're in debt and you also have to pay another fee where you're paying back more than you owe, even though they may label it as an admin fee or as a yearly fee. What services are they offering you? With that money, what does it go towards? If it's towards an actual service, that's understandable to. It's yes, agreements.
Right. That's what I'm trying to say. There is no sense. You've got called the Riba, which
Even though we describe it as a separate agreement because it's an integral part of you signing up to this thing in the first place. You wouldn't pay for that service separately without getting the card. So it's like all of these different things that you see and you come across, and when you hear some of the statements of the awam and just the lay people saying that, so forget about Islamic finance. Islamic finance is just interest that they've labeled with profit. You can kind of understand their concerns. You can understand their concerns.
100%.
Yeah.
Which is why now, Sheikh Muhammad, just on this issue, I want to ask you now, which goes back to this mas'ala we're talking about, the Ḍarūrah. Is it sometimes safer if a Muslim feels like, look, if I go down this Islamic finance way, I feel like I'm doing a healer. I feel like I'm making a trickery. I feel like I'm performing trickery in front of Allah. Isn't it not better for me to just say, Ya Allah, I'm in a situation where I can't get out of. I'm in a daruri state. Ya Allah, please forgive me, but this is what I can do. I have to just take the conventional. That's haram under the guise of darura. Because does the Ḍarūrah have an objective test that everyone has to meet, or does it change from person to person? I'm talking any person that's in an
element where they all share a certain level in common, but people are different, of course. But one thing I would say though is that has to be brought up if someone tries to argue that is you have to look at the level of haram that you're getting yourself into. So let's say, for argument's sake, there's an Islamic mortgage contract. There is a conventional mortgage contract. We know some of these Islamic mortgage contracts have things that are very questionable. From them being that, for example, when it comes to if it's a diminishing musharaka, they make you have to be liable for the maintenance of the whole property, right? Which it shouldn't be the case if you are renting their portion. It's meant to be shared because the maintenance is tabi'un lil milk. Yes, it follows the dhaman in this case. Liability follows who? It's tied directly to the owner. That's why you find, according to the four madhahib, this is a condition that's not allowed. And according to three of them, they would view it to be something that would invalidate the contract. Hanabila obviously have two ara in terms of fasidun mufsidun al-aqd or fasidun ghayru mufsidun al-aqd. Right? In terms of being invalid and invalidating the contract, or invalid and not invalidating the contract. But generally, this is something that shouldn't be happening. You find that they force you to take out home insurance. To take out home insurance where now you're completely liable for the whole of the property, even though you've only got 25% ownership of the property and you're renting the 75% from them that you don't own. You shouldn't be liable, for the whole of the property if something happens. If there's an issue with the
And when you look at the multitudes of contracts, it can go back to what the Hanabila talk about, bay'atayn or bay'atani fil
several contracts within one. So several that comes up as well in terms of buying and renting the same thing at the same time. Like, can you rent something you're buying or buy something you're renting? That's another discussion. Anyway, let's say you have these two things on the table. And a person is trying to make the argument that, if I go with this Islamic mortgage one, I feel like I'm trying to deceive Allah subhanahu wa ta'ala. But if I go with this one, I can argue the case of Ḍarūrah, that I'm in dire need. Now, I'm not encouraging anyone to take any of the opinions or to take any of these two. But I'm just saying, if someone is in this situation, they would have to weigh up the level of haram on both sides. We know the danger of Ribā. Ribā is one of the greatest sins.
we know.
On the other side, you have clauses that could jeopardize the contract. You have clauses that may eventually cause you to fall into Ribā, such as a late payment fee, which were initially, it's not necessarily a loan agreement, it's a purchasing agreement, but now you're in debt. So there's an issue with the clause regarding you paying your debt. So if you weigh up these things, you would still kind of notice that the Ribā outweighs the possible impermissibilities on the other side. So I wouldn't open that door up for people, because what tends to happen is people will use Ḍarūrah in whatever way they want.
They will just take the loan.
So that
Yeah.
specific door needs to be managed. It needs to be managed. Only those who could truly open it can open it. Truly allowed to open it can open it. But all of these different things exist in the Islamic finance world. One thing. Yeah. No, تفضل.
And this is, go ahead. No, and this is just like an introduction. So imagine one that even kind of has to do ta'ammuq and really research. You find that these contracts are never ending, like you said, So it's just like, what is the kind of solution to this? And is there a solution in reality?
It's a difficult question to answer. So, well, I think
You could say there's no
the
solution.
best solution at the time, at the moment, is what we find amongst the fiqh councils, their discussions on these issues, and them trying to come up with possible solutions, because they know themselves that you can't just give a ruling of halal and haram and just walk away. The repercussions are massive. Like, you're going to have impact on hundreds of, if not millions of people. So in many of these fiqh councils that you find around the Muslim world, they study these issues. Some try and come up with conclusions. That's why you find the AAOIFI Sharia compliance standard, where what it appears to be like is they're trying to come up with guidelines that might be the best that can be found at the moment, because of the situation the Muslims are in. But it's something where the Muslims shouldn't just take the back seat and feel sorry for themselves. They need to strive for a solution. They need to try and come up with a solution. They need to try and, look for ways to help themselves. I think it's very, very important.
Yeah. Wallah, I agree with you, Sheikh Muhammad. I agree with you 100%. And also, looking at the importance of having these fiqh councils. And, we know that Umar radiallahu anhu, if a nazila came, he would consult Ahlul Badr, for example.
Where you can try and come up with certain solutions. Each one has their own history and experience, certain communities, and many might even have experience in the finance world, working many of these Islamic banks, and seeing it from the inside, the impact it's had on communities, or the impact it's had on industry itself, But al-ijtihad al-jama'i is very important. In this day and age, you find it's very, when you look at Majma' al-Fiqh al-Islami, and you look at the reports and the things they've produced, you'd find it's great benefits.
Great.
Yeah, 100%.
Yeah. And to be honest with you, just to give I feel like, to be honest with you, these Masā'il mu'asira have kind of shown us the strength of certain madhahib. And I think that in terms of mu'amalat maliyah, you see the strength of the Shafi'i madhab a lot. Personally.
Yeah, you do. You also see the strength of the Hanabila as well, certainly. Yeah.
Hanabila, yep, you do.
One thing I would say though about those who come from the Hanafi madhab is, if you're looking for works on these issues, a lot of the time you would find muftis from the Hanafi madhab who've written on it, especially in the subcontinent.
About this a lot,
especially in the subcontinent.
In the subcontinent,
So may Allah subhanahu wa ta'ala give victory to them, and provide solutions for the Muslims bi-idhnillah ta'ala. The next topic, we're going to definitely cover something on Islamic finance, maybe a specific topic with it. I was thinking something regarding car finance. Maybe start with car finance.
Yeah.
Specifically, there's a specific company I've been looking into that presents themselves as the most halal car finance company in the UK. There are some concerning things I have seen. Obviously, I don't want to get sued. I don't want them to, be offended or anything like that. So we might not necessarily mention them by name, but definitely. I'll send you
But we
the
can go over
details
them,
بإذن الله
like-
تعالى as well.
Yeah.
But
yeah.
we'll go over the different forms of car finance and some of the
Great,
issues that
inshallah.
exist, and some of the clauses that you might
Yeah.
think, is this fine? Is this not fine?
Mhm.
Like an example is, let's say, for example, a person is not paying on time and they haven't paid for 6 months. Now you have to get the bailiffs involved.
Mhm.
You have to get the courts involved. That will cost you money.
Yes.
Can you charge that person who owes you money those fees? That's something you find in some of these contracts, which is like it's in essence it's the late payment fee, right? So many of these issues, بإذن الله تعالى, we'll see if we can cover it in our next episode, بإذن الله تعالى. Allah subhanahu wa ta'ala forgive us for any mistakes that we've made. We ask that Allah subhanahu wa ta'ala accepts from us any khayr that we've mentioned. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك.